very good afternoon, everyone, and a warm welcome to this yet another edition of the webinar on data protection organized by the law firm of Sholola and Akpana. My name is Abraham Aigba, and I'll be moderating today's webinar. Once again, we thank you for joining us with us this afternoon. This is the second edition of our webinar. I do recall that in the last webinar, we had promised to come back to you subsequently with another webinar, and here we are this afternoon. So right about now, I will be introducing our panelists who are going to run us through on this all-important topic of the responsibilities of data controllers under the NDPR, as well as consequences of non-compliance. So firstly, I have Alan Amadi. Alan, good afternoon to you, and thank you for joining up with us this afternoon.
Yeah, good afternoon. Thank you for having me. Good afternoon, everyone. I'm delighted being here. Thank you.
All right, thank you so much, Alan. Next to Alan, I have Neoma Chimeziri. Neoma, we are pleased to have you with us this afternoon.
Good afternoon, Abraham. Thank you for having me.
All right, thank you so much, Alan and Neoma, for joining us this afternoon. Like I said earlier, this is a follow-up to the last webinar we held, and we verily believe that between that webinar and this time, that some of you, that the data controller entities may have complied with your obligations under the NDPR. For those entities who are yet to comply, or perhaps still having difficulty complying, maybe due to some gray areas, certain aspects they are not sure of, or any other challenge that may be, we do hope that this webinar will provide clarity to those gray areas, those concerns you may have, and you will do well to comply with your obligations under the NDPR. So just quick ground rules before I call on the panelists to do justice to the topic. We are going to have the panelists run through, I'm sure they have their slides, so we are going to have them run through their slides. We call on you to patiently listen to them as they run through their slides with us. And then we have taken note of the questions some of you sent in the course of registering for this webinar. We are going to take those questions at the end of their presentation. And for any other questions that may be arising from their discussions, from their presentations, please do feel free to send in those questions to the panelists through the chat box, and then I'm sure they are well ready and well equipped to take your questions at the end of their presentation. So very quickly, I will call on Alan to take charge of the first part of this webinar. Alan will be speaking to us specifically on the responsibilities of data controllers under the NDPR. Alan, please, you can begin your presentation.
All right. Thank you once more, Abraham. And I'll proceed to share my screen so that we can run through the slides. I believe my slide is up now.
Yes, it is, Alan, it is.
Okay, so welcome everyone. Today we'll be talking about the responsibilities of data controllers in Nigeria. But first, let's define the terms we'll be using going forward. So what is personal data? I've been asked that question several times. What is personal data? In fact, 3 months ago, we were invited by a governmental agency, and when we came in, we were asked, why are you retaining our data? So you mean we should share our budgetary information and our state secrets with you? And we said, no, that's not what we're interested in. We're interested in personal data. And they said, what is personal data? So we had to explain to them that personal data is anything that directly or indirectly identifies a living individual in Nigeria or a Nigerian living abroad. That is what personal data is. Okay, so it's not your company data, it's not your engineering data, for oil and gas companies that engage in seismic activity. So it's not your engineering data, it's not your cash flow in the bank for companies, it's not even your VAT data for for companies that are torn between paying VAT to the FIRS or RRS. That's not personal data. Personal data is that information you collect at your front desk for visitors that come in. Personal data is BVN, email address, health records, CCTV images. All these are personal data because they identify a living individual in Nigeria or in Nigeria. So the next is, who are data controllers? Now, a data controller is a company or organization or even an individual that collects or uses personal data. Any person that collects or any person that uses is a data controller. For example, any company with employees is a data controller already. Any hospital, any school, any hotel, airport, name it. Okay, banks, insurance companies, religious centers like churches, mosques, these are all data controllers. So next is, what does it mean to process personal data? Now, processing is virtually anything you do with personal data. So if you download a person's international passport, that's the information page of international passport, you are processed. If you upload someone's personal data, you are processed. If you modify, if you analyze, if you disclose or delete, even if you print or if you send via email, you are processed. And that's the reason why we advise our clients that if you are not sure that a recipient has consented to disclosure of his or her email address, please blind copy that person. Do not copy them and disclose a person's email address to another person unless they belong to the same organization, or maybe there's an understanding that these people are all involved in the same transaction. Then you can copy them. So when you do anything with personal data, you are already processing personal data. And now every processing activity must be based. Must be founded on a lawful basis. So you must have a lawful basis for processing personal data. Now, what are these lawful bases? There are 5 of them under the NDPR. Okay, there are 5 of them. So one of them is consent of the data subject. Now, consent, or rather, for you to rely on grounds of consent, it needs to be informed consent. Then it needs to be voluntary consent. Then it needs to be an affirmative act. Let me explain this. It needs to be informed consent in the sense that you need to inform the individual what data you're collecting, what you're going to use it for, how long you keep it, whom you're going to share it with, how you're going to delete it or destroy it when you no longer need it. You need to inform that person of all these, you need to explain all of this to the obtain consent, and that's where the privacy policy comes in. All these are contained in the privacy policy. So take for instance, if your organization uses the CCTV camera and it is positioned at the entrance of your organization such that it captures the image of individuals even before they come into your premises, even before they consent. If your organization deploys that, then they ought to have a conspicuous notice stating that by entry and remaining on these premises, you consent to our collection and use of your personal data in line with our privacy policy located at the organization's website.com. I mean, you have to state that so that if the person remains on the premises after citing that notice, then the person is deemed to have consented. You can rely on consent for that. Otherwise, you may find it difficult to find a lawful basis for collecting people's images via CCTV camera. So that is it for consent. It has to be informed consent. It has to be an affirmative act, and it has to be unambiguous as well. Then the next is performance of a contract. Okay. My monthly salary. They need to process my payment details. The account department will need to process my payment details before they can pay my salary. So when they are processing my payment details, their lawful basis for doing so is performance of the employment contract. So whenever there is a contract that requires processing of personal data to fulfill, then there's a lawful basis being the performance of the contract. And another lawful basis is legal obligation. So I went for a function, and we required, or I wanted to lodge in a hotel. And at the front desk, the receptionist was asking, gave me a form, asked me to fill out. And after that, they were entering my details on a portal. And I asked them, what are you doing? And they disclosed to me that we share this information with the DSS. They want to know people who log in and log out. And we're also required to keep our CCTV camera recordings for a minimum of 3 months before deleting. So as soon as I learned that, and I knew that, they are personal data with us. So they do that pursuant to the legal obligation. The same thing with banks. There are transactions of a certain threshold that banks are required to disclose to the NFIU or to the CBN. They do that under a legal obligation. And another lawful basis is vital interest. Okay, this one has to do with life or death scenario. During the Euro 2020 competition, a Danish footballer, Christian Eriksen, slumped on the pitch, and he required urgent medical attention. So the medical team in the stadium could request his doctors, his medical service providers to send his electronic health records via email, and they will quickly send it, relying on vital interest of the unconscious individual. So that is also another lawful basis for processing personal data. And there's a fifth one, which is performance of a task in the public interest. This is relied upon by most governmental agencies like the EFCC, the police, the DSS, the NFIU. Anytime they're required to investigate or to take an action in the interest of the public, they also have a lawful basis for doing that. So these are the 5 lawful bases. If you are processing personal data and you cannot situate it on any of the lawful bases, then it is an unlawful processing of personal data. Now, we've defined personal data, and we've defined data controllers, and we've identified the 5 lawful bases. Let's talk about the obligations on data controllers. As a data controller, which we have established, obligation to inform or duty to inform, which is, we're talking about the privacy policy. There is a duty to inform individuals at the point of collection of their personal data. Then there's also the duty to possess technical and organizational measures. Let me explain this a little bit. Technical measures refer to things like encryption, firewalls, having a strong antivirus, deploying login technologies, okay, and you know, cloud backup. All these are technical measures. So as a data controller, you are required to have the technical measures in place, minimum technical measures, because security is an expensive venture, and you just provide the ones that you can read. Password policy, there are quite a lot of those policies, up to 30 or 35 of them, which you reasonably need to have. That's where you know, consultants come in, with clients that but you need to have that, and you need to sit with your consultant to have those in place. So remember, technical measures and organizational measures, they go together. Then next, you need to ensure continuous capacity building for your staff members. Continuous capacity building. In fact, on an annual basis, there is the 20 and audit annexure A. Now, in the audit annexure, there's a question that goes, have you trained your staff members in the past 1 year on data protection compliance? And the moment the answer to that is no, or you answer yes, but really is no, you tend to lose points. You tend to, you know, be downgraded to a non-compliant entity. So you need to ensure continuous capacity building, and we provide this to a lot of clients, including the Central Bank of Nigeria, that is engaged in continuous capacity building of its employees. I mean, if the CBN can observe this, then almost all data controllers need to, because these are regulators. So kindly note, you need to ensure continuous capacity building, and we provide that as a service. Then next is, you need to have an in-house data protection officer. And by that, I refer to organizations that process sensitive personal data. Now, sensitive personal data refers to health records, political records, sexual orientation, ethnic records, anything that has, yes, political, ethnic, health, local government, state of origin, health records, all these are sensitive personal data. So if you have a form that if you have a form in which you collect this sensitive personal data, then you need to have a data protection officer. You are required to have that. Then also, if you are a governmental agency, you're also required to have a DPO. If you process the personal data of 10,000 individuals in 1 year, you are required to have a DPO. And please, let me note here, when we say process 10,000 data subjects / individuals, we mean if you have even a CCTV camera positioned to the road, and you know that on that road, a lot of people walk past and it's a very busy road, you are deemed to process because you are capturing people's images, whether you store it or not. Okay, so please note that you are required to have an in-house data protection officer when you fall under any of this description. So next is duty to conduct a data protection impact assessment test before executing project. Like I said again, if you have or deploy cameras, as you have done a DP before deploying it. There is a case that comes to mind, the case of Bridges versus Chief Constable of Yorkshire. Let me quickly just share something with us. NDPR. Okay, in that case, something happened. The claimant, Mr. Bridges, took the police to court. Now, what happens is that in England, the police patrol vehicles usually have, they come with a dash cam, and the dash cam will capture people's facial data and compare it with compare it with a database of wanted persons, and the moment it matches, the police officer is notified to move in and effect an arrest. So when the police is driving by, they're actually capturing personal data and they're analyzing at the same time also. So Mr. Bridges passed by a police vehicle and his personal data was captured. And after a while, he exercised something called a data subject access request. That is asking the police, please disclose what personal data you have about me. And the police obliged that and said, we have your facial recognition, that's your image, which we captured on dash day or dash. Then after that, Mr. Bridges now wrote again to the police saying, can you provide me just a scanty DPIA, probably a 2-pager or thereabouts. But at the Court of Appeal, the Court of Appeal now struck down the DPIA, saying that it was not okay. I believe my screen is up. So on the screen is an ICO DPIA template. The things that the things that should be contained in a DPIA. So you can see that step one is to identify the need for a DPIA. The processing is quite lengthy. Won't go through all of it, but the average DPIA is, and it was on that basis that the court struck down the scanty DPIA that was conducted by the police. Then moving on. Okay, so there is no technology. Then next, there is a duty to engage a licensed data protection compliance organization to audit and file your annual report to NITDA on or before March 15 of every year. For this year, it was extended to June 30, but as a data controller, you need to engage a DPCO to audit and file, where number one, you process the personal data of 1,000 data subjects in 6 months, or you process the personal data of 2,000 data subjects in 1 year. Now, we've had instances where people say, we don't process up to that, so it doesn't apply to us. If you say you don't process up to that, then you need to bring an inventory of how much you actually process. And if you have a CCTV camera positioned to positioned on a busy road, then the burden lies on you to prove that you actually process less than that. So please note, you need to engage a DPCO to audit and to file, and we do that for our clients. We've done that even in 2019, 2020, and even this year. It's actually a very serious compliance step, because when you go on NITDA's website, there is a list of NDPR compliant organizations, the ones that have filed their audit report. And sometimes when you're talking to a company, when you're trying to bid for something, the due diligence team in that organization will go and check that list to see if your organization is on that list. It is a point of due diligence. So please note this, and also try to comply if you are not. Then and a breach. Okay, but whenever there is a breach, it happens. Obligation is duty to ensure that all joint controllers, third parties, and sub-processors are bound by a data sharing agreement or processing agreement. So what this means is that if, as an employer, you collect personal data and you now wish to share, that database with another organization, you need to ensure that you enter into a service level agreement or some form of data sharing agreement with that organization before you share, to ensure that your obligations to the individuals that you collected their personal data is also shifted or shared with that you are going to share personal data with. Then there's also a duty to observe data protection principles. There are about 6 data protection principles, and you need to comply with all of them. For instance, there's security, and there's adequacy, there's lawfulness, there's availability, and all what have you. There are about 6 of them. Then next is what happens when an organization is in breach of these obligations. The first one is your employees can sue you, and that's serious enough. That's very, very serious. So let's take, for instance, if you want to dismiss an employee that has that is guilty of gross misconduct, that employee can turn around and blackmail the company by saying that, oh well, I'll also sue you for not handling my personal data. All right, so your employees can sue you. It's very, very serious. Okay, and of course, already, I don't know, for those in the oil and gas, you can see that there's a lot of frivolous litigation going on, and you don't want to add to that by giving employees and host communities the leeway to sue you for data breach. The next is a high risk and non compliance. Let me share something with us. Transaction. A client wanted to raise funds from a foreign investor, about $8 million. So at the due diligence stage, so in a recent transaction, a client wanted to raise funds, a Series B fund, $8 million from a foreign investor. So at the due diligence stage, there's something called ESGDD, environmental, social, governance due diligence, usually conducted when significant amounts are sought to be provided under a funding arrangement. So at that ESGDD stage, it now dawned on these clients that if they don't have a data protection officer, if they don't have an adequate privacy policy, if they don't have the adequate measures and the policies in place, they won't get the funding. So what happened was that they immediately reached out to us and appointed us DPO, and also sought to engage us further, because out there, investors are risk averse. And the moment you don't have data protection compliance structure around your operations, you become a risk entity, and they will not want to fund. So this is also a very, very important part to scare away potential investors. Then next is, it is now a corporate governance requirement. If you follow the trends around the world, you see that companies are now required to be socially responsible. Okay, so it's not just about making profits. You have to protect the personal data of the people that you work that work under you, of the people that do business with you. That is called environmental, social governance report. So it's not a requirement that you capture data protection operations under the ESG and the corporate governance report. Then also, if you fail to observe these obligations, you open yourself to significant government investigation, sanctions, and even brand damage. This is my colleague Norma will come in to explain very well, but as you are aware, or as you may be aware, NITDA sanctioned SOCO loan and some other companies. Even the Lagos Internal Revenue Service was sanctioned by NITDA, 1 million naira fine plus other compliance sanctions. So you see that when you fail to observe this, you open yourself to significant government investigations. So quickly, before I hand over, let's just run through everything I've done. The first is personal data. We've identified personal data as anything that identifies a living individual in Nigeria or any Nigerian abroad. Then next is a data controller is anybody who receives or uses personal data. It's as simple as that. If you receive, if you use, if you hold, you are a data controller. And after that, we talked about processing of personal data. Anything you do with personal data, anything, just think about it. Anything you do with personal data is processing. And you must have a lawful basis for processing. There are 5 lawful bases. So let me throw this question back to us. Have you ever received a message from a loan company saying XYZ is on the run and kindly be careful with him? Now ask yourself, what is the lawful basis for that company to send that message to you? It's kind of like a brain teaser. Then after that, we talked about obligations of data controllers. We talked about obligations to inform, technical and organizational measures, capacity building, in-house DPO, DPI, very, very important. Remember, Bridges versus Chief Constable of South Wales Police. Then we also talked about duty to file your audit report with NITDA. Please make sure your organization is on that list of NDPR compliance entities. It's on NITDA's website. It's public, very important. Then after that, duty to notify NITDA within 72 hours of becoming aware of the breach. And there's a duty to ensure that the people you share personal data with are also responsible to the degree that you are responsible. There's duty to observe data protection principles, and failure to observe these obligations have significant consequences, like you can be sued, investors can walk away from you, and of course, if you are going to list on foreign stock exchanges, you are required to have a strong corporate governance structure, and that is where data protection compliance comes in. If you don't have it, you are deemed not to have a strong corporate governance culture, and you open yourself up again to significant government investigations, sanction, and brand damage. So this is the summary of your duties and the consequence of not observing your duties. I'll be handing over to the moderator now. I'll be back for questions, and thank you for obliging me with your time. Thank you.
All right, Alan, thank you very much for that. I should say that's wonderful presentation. Well, it sure did feel like I was in the classroom. I'm sure our audience too may have felt the same whilst you spoke. So thank you so much. You have made quite a number of points stressing on the essence of data protection, what is data, what is personal data, the obligations of data controllers under the NDPR. You stress so much on the DPIA and other things. I have some questions have come in for you, and like I did say at the beginning of this webinar, we note that in the course of registering for the webinar, some persons sent in some questions, and today we have received some questions while Alan was speaking. And then, like I said earlier, we will take all the questions at the end of the presentations by both panelists. So Alan has done this presentation, a wonderful presentation at that. With his presentation, we have come to the end of the first segment of this webinar, that is one of 3. So right about now, I will call on Neoma to make her presentation. Neoma is going to be talking to us on the consequences of non-compliance with the obligations or the responsibilities mentioned to us by Alan. So Neoma, if you may, please have a presentation for us.
Thank you, Abraham. Okay, so I'll be speaking on the consequences of non-compliance with the Nigerian Data Protection Regulation. But I'll quickly share my screen now. My colleague Allen has actually spoken extensively on the responsibilities of a data controller under the NDPR. Now, the question I will ask at this point is, are there attendant consequences for non-compliance with the NDPR? This question will be answered in the affirmative. But before I proceed to the consequences of non-compliance with the NDPR, I would like to take us through some of the enforcement mechanisms put in place by NIDA as a regulatory agency to ensure that data controllers comply with their responsibilities under the NDPR. Now, one of such mechanisms is surveillance. Surveillance is a monitoring mechanism used by NIDA to monitor the activities of a data controller. Now, NIDA would use this mechanism to ensure that the policies and practice of a data controller conform with the NDPR. Now, how is this possible? One of the responsibilities of a data controller under the NDPR is that the data controller must file its annual audit reports to NIDA. Now, where a data controller has filed its annual audit report, NIDA will review the audit reports previously filed by a data controller in line with the data controller's data protection practice. Also, my colleague talked about the technical and organizational measures. Now, the technical measures has to do with the security measures a data controller has to put in place. One of such security measures, he said, was encryption. We also have antivirus and strong passwords. Now, these security measures are always required by a data controller to ensure that the personal data of data subjects in its possession are protected and not readily made available to a third party. Data controllers are also required to maintain the relevant data protection policies. Some of these policies are the privacy policy. Now, a privacy policy of a data controller must be one that must be understood, easily understood by the data subject. We also have the DPIA, that is the Data Protection Impact Assessment Policy. We have the Remote Access Policy, we have the Cookies Policy, and some other policies that are required to be maintained by a data controller. So when NIDA reviews the policies, the audit reports of a data controller, they use this surveillance mechanism to ensure that a data controller conforms with its responsibilities under the NDPR. Another mechanism we'll be looking at is complaint filing. When you hear complaint filing, what comes to mind? Reporting. A data subject can report to NIDA where he believes that his personal data has been processed without his consent or was not processed in accordance with the lawful purpose and basis for processing personal data. Now, let's say, let me paint a scenario where a company sends out SMS or makes a phone call to persons, individuals, saying that a particular person has collected a loan and the debtor has failed to pay, he's on the run, he's not a trustworthy person, that you should not deal with such a person. Now you find out that the data subject whose personal data was processed at this point was not done in accordance with the lawful basis of processing personal data. And such a data subject can file a complaint with NIDA to that effect. Aside from a data subject, organizations, governmental agencies can also do what? File complaints with NIDA, where they believe that a data controller has not complied with its responsibilities under the NDPR. We also have investigation as a mechanism. Where a complaint has been filed by a data controller or an organization, the next step NIDA will take is to investigate the complaint filed against a data controller. NDPR has an investigation process, a process followed by NDPR to ascertain whether or not the complaint filed against a data controller is true. Now, the next slide is a summary of the investigation process. And the first step in that investigation process is for NDPR to invite the concerned entity or the data controller against who a complaint has been filed. Now, NDPR will invite the data controller. This complies with the principle of fair hearing under the Constitution. Now, for NDPR to hear both parties, the data subject has filed its complaint. NDPR will also hear the data controller against whom a complaint has been filed. Where a data controller, if a complaint has been filed against a data controller, say a data subject filed a complaint to NDPR stating that his personal data was not processed with his consent or was not processed in accordance with the lawful basis. Now, questions that NDPR will put to the data controller is some of the questions are: do you have a privacy policy? Is your privacy policy one that is easily understood by the data subject? In your privacy policy, is it stated that the data of a data subject will be processed for a particular purpose? So these are some of the questions that NDPR would ask the data controller at the inquiry stage. NDPR can also review the annual audit report. Recall when I was talking about surveillance as a mechanism, we said that NDPR would review the audit report filed by a data controller, the policies of a data controller, to ensure that they conform with the NDPR. So this is another step in the investigation process. NDPR would review the audit report. Also, NDPR can issue a query to the data controller. Now, I will state at this point that where a query is issued to a data controller, the data controller must ensure that the response to such a query is honest, true, and correct. How will NDPR find out if such a response is correct? This will take us back to the second process I talked about. NDPR would review the annual audit report. So you find out that the steps, the investigation processes are connected. NDPR will take it one step at a time. So where a query has been issued, and for NDPR to ascertain whether such a response is true, NDPR will still have to go back to the audit report filed by the data controller, the policies maintained by such a data controller. After investigation, and NDPR ascertains that a breach has indeed occurred, NDPR may impose what is called administrative sanctions. We'll look at some of these administrative sanctions shortly. NDPR can also proceed to prosecute the data controller. And this takes us to the next mechanism. We have administrative sanctions. I want us to follow the sequence of this enforcement mechanism. We talked about surveillance, we talked about complaint filing, we've talked about investigation. Now we're talking about administrative sanctions. Where a complaint has been filed, the next step is for NDPR to investigate. And after NDPR has investigated and ascertained that a breach has occurred, NDPR may impose what is called administrative sanctions. Now, some of these sanctions are fine. NDPR may impose a fine on the data controller in breach. NDPR can also request that an audit is carried out by the data controller, but not by the data controller. The data controller has to engage a DPCO, that is a data protection compliance organization, to carry out the audit filing. We'll look at these administrative sanctions in details when I talk about the consequences of non-complying with the NDPR. We also have criminal prosecution as a mechanism. Now, when NDPR concludes an investigation upon the receipt of a complaint, NDPR can proceed to prosecute the data controller in breach. How will NDPR commence this criminal prosecution? NDPR will seek a fiat from the Attorney General to commence a criminal action against the data controller who is found to be in breach of the NDPR. So these are some of the mechanisms put in place to ensure by NIDA to ensure that data controllers comply with their responsibilities under the NDPR. This brings us to some of the consequences of non-compliance. Recall I earlier asked the question, where are there attendant consequences for non-compliance with the NDPR? One of such consequences is fines. Now, where NIDA has ascertained that a breach has occurred, NIDA may impose a fine on the data controller involved. Fines are monetary sanctions to be imposed on a data controller for breach of its responsibility. Now, will NIDA impose any sum as fine? This is not the case, because whatever fine NIDA will impose on a data controller must be in accordance with the NDPR. I will illustrate this because some data controllers still don't understand how NIDA arrived at the fine imposed for breach under the NDPR. Where a data controller deals with more than 10,000 data subjects, the fine to be imposed in this situation is 10 million naira, or 2% of the annual gross revenue of such a data controller, whichever is higher. Now, what this means is that if the annual gross revenue of the data controller is 100 million, 2% of the 100 million will be 2 million naira. So NIDA has two options to choose between. NIDA has two options: the fixed amount of 10 million naira or 2% of the annual gross revenue, which is 2 million naira. In this instance, NIDA will go for the 10 million naira, the fixed amount, since the 10 million naira is higher than the annual gross revenue. On the other hand, where the annual gross revenue is higher, NIDA will go for the annual gross revenue. Also, where a data controller deals with less than 10,000 data subjects, the fine that NIDA would impose in this case is 2 million naira, or 1% of the annual gross revenue. From the earlier instance I gave, where the fixed amount of 2 million is higher than the 1% of the gross annual revenue, NIDA would go for the higher amount, which is 2 million naira, the fixed amount. But where the gross annual revenue is higher, NIDA will go for the annual gross revenue. So this is how NIDA arrives at sanctions or fines imposed by data controllers for breach under the NDPR. As you are aware, NIDA has sanctioned 2 organizations this year for breach of data privacy rights. We have the Electronic Settlement Limited and the Soko Lending Company. These organizations were sanctioned because NIDA conducted its investigation and actually found that ascertained that a breach has occurred. These organizations were fined with 5 million naira and 10 million naira respectively. Wow, this is a huge sum to be paid by an organization, even SMEs. This is actually a huge amount to be paid, bearing in mind the economic situation of the country. This shows that NIDA is set to sanction non-compliant organizations moving forward. It is advisable that data controllers comply with their responsibilities under the NDPR. I must state at this point that complying with the NDPR is cost-effective as against the huge fine that will be imposed on a data controller for non-complying with the NDPR. Recall that fines are not the only sanction that NIDA may impose. When we looked at administrative sanctions, we talked about fine and some other consequent administrative sanctions that NIDA can impose. So fines will not be the only sanction that a data controller would face for failure to comply with its responsibilities under the NDPR. Now we have prosecution. Where a data controller is in breach of the NDPR, NIDA can prosecute the data controller concerned because the data controller has failed to comply with its responsibility, which results in breach, NDPR can seek a fiat from the Attorney General to prosecute the data controller. Also, we have another consequence, reputational damage. We talked about fine, we talked about persecution and prosecuting the data controller. Where a data controller has been fined, a data controller is actually facing criminal persecution by NDPR. This will affect the reputation and good standing of such a data controller with its investors, with its customers and business associates. Now, if an investor wants to invest in a company, the investor will carry out its due diligence to ascertain that, okay, it's safe for me to invest into this company. Where an investor has carried out its due diligence and discovers that the company has been fined by NDPR or is being persecuted, is facing a criminal persecution by NDPR, you find out that the investor will not want to invest in such an organization, because the investor will have at the back of his mind that such an organization is not a compliant organization. It has not complied with the relevant laws regulating its business. So this affects the reputation of a data controller. NDPR can also issue public notice to the general public. When NDPR issues this public notice to the general public, NDPR will issue a notice saying that this organization is actually undergoing investigation, that the public should not deal with the organization or data controller at this point, because the data controller is undergoing investigation. Now, where a public notice is out there and the general public is aware that a particular organization or data controller is being investigated by NDPR, this also goes to affect the reputation of such a data controller. We also have suspension as one of the consequences that a data controller would face for complying with the NDPR. NDPR can also report the data controller to its self-regulatory organization. I'll explain this. We all know that the telecommunication industry is regulated by Nigerian Communications Commission, that's the NCC. The medical practitioners are regulated by the Medical and Dental Council of Nigeria. Now, where an operator under any of this industry is in breach of his or her responsibilities under the NDPR, NDPR will report such an operator to its self-regulatory organization. Say, for instance, an operator in the telecommunication industry is in breach. NDPR will report such an operator to NCC for the appropriate disciplinary measures. So these are some of the consequences of non-complying with the NDPR. For everything that has a disadvantage, there are also advantages to it. This brings us to some of the benefits of compliance. Now, recall I said that complying with the NDPR is cost effective. Now, where a data controller has complied with the NDPR, it is more economical, because where a data controller has complied, the data controller will not be exposed to sanctions like fine, persecution, and all other sanctions. So in such an instance, the data controller has saved more by complying with the NDPR rather than exposing itself to the huge fine that will be imposed by NDPR in the event of a breach. It also builds trust between a data controller and its investors. I explained that an investor would feel safe to invest into a company that is compliant with its statutory obligations under the relevant laws regulating such a data controller. A better understanding of collected data. Now, a data controller is required to maintain what is called an inventory schedule. This inventory schedule contains the name of the data subject, the personal data of the data subject collected, and the processing activities carried out on such personal data. Now, where a data controller has an inventory schedule, the data controller would easily know the amount of personal data it has in its possession, the amount of personal data it processes on daily basis. So it gives a data controller a clear understanding of personal data collected. It also enhances enterprises and brand reputation. We talked about reputational damage when we're looking at the consequences, and we said that where an organization is fined or where an organization is persecuted by NDPR, that it affects the reputation of such a data controller. On the other hand, where a data controller has complied with its obligation under the NDPR, the organization actually has a good reputation and it has a good standing with its investors, because investors would invest in a company that has complied with its statutory obligations under the relevant laws. Now, we've looked at the responsibilities of a data controller. We've looked at the enforcement mechanism. We've also looked at consequences of non-compliance and the benefit of compliance. Two options are open to a data controller. The first is comply with the NDPR and enjoy the several benefits. The second is face the risks of being sanctioned by NDPR for non-compliance. It is therefore advisable that data controllers comply with their responsibilities under the NDPR as against exposing an organization to being sanctioned by NDPR. We also advise data controllers to engage the services of a licensed data protection compliance organization. As a data control, as a licensed DPCO, Sholola and Abana has provided this service for several organizations to ensure that they comply with their responsibilities under the NDPR. Thank you.
All right, Nama, thank you so much for that presentation. Well, so much said, so much has been had. Implementation, I guess, is next and is the key to all this that we have said about the duties of data controllers under the NDPR. Well, we are having some questions here. Okay, we're having some questions here, and we have some questions that we are sent to us prior to this time. Some of the questions I can see are largely similar to each other, so I guess I'll just have to merge them and throw them to a particular panelist. Some of them are addressed to a named panelist, some of them are not. And okay, so I think we can go into the third and the final segment of this webinar, which is the question and the answer session. The first question, well, I wouldn't know who to address this question to because it's not been addressed, and I think both Alan and Norma made reference to it. And this question was actually sent in before now. So the question says that it has become a common occurrence for persons to receive unsolicited calls, SMS from some money lending platforms, informing them that a friend or a relative took a loan from them and has not repaid the loan. And I don't know why laughing. So, okay, that has not repaid the loan, and asking them to reach out to the said friend or relative to make good this indebtedness, and in some cases even threatening to block the accounts of these of these persons. Now, the person asking this question has said that I personally find this very irritating, to be honest. And now he's asking that, is this not a breach of the NDPR? And what redress can I seek against such money lending platforms? So, like I said, both Alan and Inoma has made reference to this in the course of their presentation. So I guess the both of you would speak on this. But Inoma, I think you should go for, since you spoke more on the consequences of non-compliance.
Okay, thank you very much, Abraham, for that question. Indeed, this is now a common occurrence. I would like to share my own experience with some of these lending companies. Now, I received an SMS containing the name of the person and phone number of the person, stating that a particular person has collected a loan, he's on the run, he's not a trustworthy person, he's dubious. You know, when I received this SMS, the first thing I did was to call the person and ask, I just received this text message. What happened? What did you do? But I did not, at that point, I did not avert my mind to the fact that my personal data has also been processed without my consent. Now, it's very funny that some data controllers would send an SMS or call an individual saying that a person has collected a loan and has not paid, without obtaining the consent of the data subject, and also not averting their mind to the provisions of the NDPR regulating data processing. Now, under the NDPR requires that every data must be collected and processed for a specific, legitimate, and lawful purpose. Note the keywords here: specific, legitimate, and lawful purpose. And such processing must be fair and transparent. My colleague Alan talked about the 5 lawful bases for processing personal data. We looked at consent, we looked at performance of a contract, we looked at vital interest, legal obligation, and public interest. These are the 5 lawful bases for processing a personal data. Now, the question is, was my personal data from my own experience, was my personal data processed with my consent? No. Was it for a performance of a contract? I did not enter into a contract with the data controller. Was it for vital interest, public interest? The answer to all these 5 questions is no. So in this case, the data controller has processed my personal data without my consent, and it was not done in accordance with the lawful basics for processing a personal data. So a breach has occurred. I think that has answered the first part of the question. Now, on the issue of redress, a data subject, what are the redress a data subject can seek? Now, the first redress is a data subject can actually file a complaint with NDPR. We talked about complaint filing. We said that a data subject who believes that his or her personal data has been breached can file a complaint with NDPR. And we said that the complaint can either be filed in paper or electronically. So a data subject has the right to file a complaint to NDPR, stating that my personal data has been processed not in accordance with the lawful basis. Also, a data subject can also exercise its right of access to retrieve its personal data from the data controller. This the data subject can do through the DSAR, that is the data subject access request. The data subject also has a right to be forgotten. The data subject can request that the data controller deletes every personal data of the data subject it has in its possession. The data subject also has a right to object to further processing of his or her personal data. So these are some of the rights and the rights of a data subject. So I think I've answered the question from the angle of whether the processing amounts to a breach, and the redress that a data subject can also seek. Thank you.
All right. Thank you so much. Thank you. Alan, I think
I have nothing else to add. I mean, she has aced it. Nothing else to add.
okay, so you adopt her submission as yours.
I adopt it hopefully, and I have nothing useful to add.
Okay, all right, Alan, thank you for that. Some of the questions from today, before we go over to the ones we got before, well, quite a lot. I hope we will have time for. Okay, Alan, this question is for you. It says, will you consider the duty to conduct a DPIA the same as conducting due diligence in the process of it, or is that just a part of it? No, you are muted, Alan. Kindly unmute yourself and start over.
Okay, thank you very much for noting. To answer the question, I consider it a part of a fuller value chain. So if you are an oil and gas company, you need to do EIA, right? Environmental Impact Assessment test. Now, if you employ members of the host community and you process personal data because you have employees, you also need to do a DPIA. Okay, then if you use natural resources, you also need to do a sustainability assessment. So this is a full value chain, and data protection is just a part of it. All right. So for those that do ISO 27001, 9001, and so on and so forth, they do everything compact. So data protection impact assessment is one of the assessments that you do together with other information privacy assessment. There's something called pen test, penetration testing. There's something called vulnerability testing. There are several of those tests that you need to do. I don't know if that question was answered. DPIA is one out of the several tests that you do. But when you sit down with a consultant, for instance, when you talk to us, we can analyze your activities. Okay, so when you sit down with a consultant, for instance, we can analyze your activities and tell you the test you need to do, the assessments you need to do, and so on and so forth. That's the answer to that.
All right, Alan, thank you for that. I think we'll just take the questions. We have about, okay, let's just see how far we can go with the questions. Okay, the next question, Alex, still to you. I think you said too much, so too much questions for you. Are there mechanisms, whether administrative or judicial, to review, challenge, or query perceived wrong findings of non-compliance and consequent sanctions by NISDA?
Okay, yes. Actually, there is an ARP, Administrative Redress Panel. Okay, so just follow my illustration. A data protection breach can be, can be addressed by, that is administratively. It's either you report to NISDA or NISDA investigates. Now, when an individual reports to NISDA, NISDA would sit as the judge, okay? NISDA is not the one investigating and finding faults. They are the ones receiving complaints. So at this stage, NISDA will just invite the organization that is being accused to reply, and NISDA can sanction as a judicial, body, so sorry, exercising judicial functions. Okay, so NISDA can sanction when it receives complaints after hearing the other side. But when NISDA moves to investigate and to find faults, NDPR cannot, proceed to sanction under that instance because it will be the accuser, it will be the judge, it will be the enforcer. So in that instance, it will usually refer to the ARP. Okay, it's like it's a forum where aggrieved persons come and they are heard, and the panel has 28 working days to deliver a written recommendation. So I believe that any person who is sanctioned without a fair hearing can challenge it. It's constitutional, and we are even doing a write-up regarding that as regards some fines that have been meted out against organizations in the past, reviewing the rule in Mobile and Nostra, section 36, 1 of the Constitution, and all that. But to answer the question, there is an ARP, okay, for when NDPR is investigating, and also there is a hearing arrangement for when NDPR is receiving complaints. That's the answer.
All right, Alan, thank you so much for that. We are running behind schedule, and there's a question. Okay, I think I'll just read verbatim. Now, this person is saying, my question goes to Nyama. Firstly, her presentation was succinct. All right. My question is with regards to consequences of information entered in the comment sections of most social media platforms. Are such entries 100% confidential and safe? So that is the first arm of the question. I think you should take this first arm before we go to the second arm of the question.
Thank you, Abraham. Now, for social media platforms, information entered into social media platforms are deemed to have been consented to by the data subject who gives such information to the social media platforms. So now recall we looked at basis of the lawful basis of processing personal data, one of which was consent. So where a data subject consents to such information, processing of such information by giving out such information to the social media. Now, this information, he has consented to it. So consent has been established as a lawful purpose for processing such personal data.
Okay, so that processing is valid on the basis of consent. That is okay. So the second arm of that of his question, which is similar to one of the questions we received before now. So I think we'll just merge these two questions. That's the question before now was whether a data subject can demand compensation for breach of his personal data. And second arm of this question is saying, how can I enforce my rights if my rights have been breached? So I think you should just answer both questions. I think they can be answered together.
Okay, thank you, Abraham, for that question. Now, when I made my presentation, we talked about some of the consequences of non-compliance with the NDPR. And we looked at some administrative sanctions that can be imposed on a data controller in the event of a breach, one of which is fines. We looked at suspension. We looked at neither issuing public notice to the general public. We also looked at reporting the data controller to the self-regulatory organization. So these are some of the administrative sanctions that NDPR can impose. Now, in addition to these sanctions or these administrative sanctions, a data controller has a right to seek redress from a competent court. Now, where a data controller believes that his personal data has been breached, such data controller can approach a court, file an action against the data controller, where the data controller actually suffered a loss as a result of the breach. The data controller can ask for compensation or damage from the court, from a competent court. So this is in addition to the administrative sanctions that can be imposed by NDPR. a data subject can also seek redress from court by way of litigation. Thank you, Abraham.
Okay, thank you. A follow-up question is coming on this and is addressed to Alan. So I think Alan, just if you may, can just add to what Norma has said. I think it should take care of the follow-up question.
Well, thank you. Please, two things. When you receive an email or you receive a message, you are not processing. For you to process, you need to take an action. So when for instance, if S&A posts a newsletter and people now comment under it, S&A has not processed anything because we are receiving. But when we now extract their names and their email addresses to send something to them, then we are processing. So receiving on public pages is not processing until you take a step towards that. For instance, if we have cookies on our website, we are taking, so that's processing. But when you stay on your own and someone sends you an email, at that point, you are not processing, the person processed. But when you now reply, you are processed. I also need to clarify that.
Okay, so in essence, you agree with the redress that she, the redress mechanism she has identified. Okay. I think the penultimate question, this is coming to you, Alan. It says, how will you advise startups to ensure constant compliance or show readiness to comply with the NDPR? Can they do this through the engagement of a DPCO, such as your firm? Considering that in recent times, most venture capitals and international financial organizations, including the World Bank and International Financial Corporation, require startups or SMEs to exhibit strong data protection policies and compliance or readiness to ensure such compliance as a prerequisite to assessing funding or financing.
Yes, we are able. We are correct. Now, we understand that startups, when they are starting, they often don't have it all. They just have a very, very big goal, and they are playing in a sector that is very promising. We have an arrangement where we can have something flexible for them, and we can be on record as their data protection compliance partners, so that when these venture capital funds or PE companies, private equity companies, want to fund the operations of a startup, and they are asked, what are your data protection policies and structures, they can just refer them to us, and we will deal directly with the VC or with the PE. Take, for instance, the NCC has pointed out that your phone numbers do not belong to you. Okay, they are just assigned to you, but they do not belong to you. They still remain properties of the NCC. So if you travel abroad or for some reason you are not using a line for a period of time, they can reassign it to another person. And when that person does a welcome back or starts using your number and dials your bank code, the person can actually have access to your to your funds if it's linked to that number. So these are some crucial things that that was brought to my notice this morning, and I don't think that we should have another webinar session for it. Very, very serious privacy concerns. Okay.
Yeah. Alan, I think I should go with your last with your last comment, because we seem to be having tons of questions today, much more than we expected, and as I speak, more are still coming. So I think at this point we may have to throw in an apology to persons whose questions we are not able to take today. Maybe we'll work towards doing another webinar where we can address some of the concerns you are raising. But just the last question for today, like I said, we do apologize for questions we may not be able to take. You can also send in your questions to us after this webinar, and we will be happy to respond to them. So the last question still goes to you, Alan. And this is somewhat similar to the last one you answered. It says, as an investor, what are the proof that a particular company is in compliance with the NDPR?
It's very simple. I'll ask for their reports, for their audit reports, their latest audit reports. If they don't have one, that means they don't even know what compliance means. If they have one, then I'll start taking them on the things they are represented in that audit report. It's as simple as that. That's the starting point.
Okay. Alan, thank you. Thank you so much for that, for your presentation. Nama, thank you. Our sincere apologies for questions we are not able to take today. We are, this webinar has run for more than the scheduled period. So we will be drawing the curtain on this on the webinar today. At this point, like I said, we will look to come your way again to address some of the questions we are not able to address today, as well as look at some other issues arising from our presentation today. Some persons are asking for the recorded version of this webinar. We do have the recorded version of this webinar, and we will pass, we will communicate means of assessing it to you in due course. Now, for this purpose, we will be making the announcements via our social media handles as to how you can access the recorded version of the webinar. We also have our newsletters. We will also make that communication through our newsletter. So, to subscribe to our newsletter, log into our website at www.sololaakwana.ng. Subscribe to our newsletters for news as to how to get the recorded version of the webinar, as well as the subsequent webinars and events we will be organizing on these issues and other topics of law. You can also follow us on our social media handles, on Facebook, on Twitter. Okay, sorry, so that I will not be sanctioned by Buhari. So follow us on Facebook, on LinkedIn, and other social media handles to get information as to this webinar and other events that we would be organizing. And then finally, we wish to express our appreciation to you for being a part of this event. We thank our panelists. We thank Alan. We thank Norma. Yes, Alan, you were with us the last webinar, and we did make the request that when we call on you, you should come back, and here you are. Thank you so much, and we hope that subsequently you also hit to our call positively. Norma, thank you. Your first time with us. So many comments about your presentation. I'm not able to read them out to you now because of time, but thank you for your presentation. And to all our viewers, thank you so much for being a part of this webinar. And until we come your way again, from us for now, it's enjoy the rest of your day and goodbye for now.